I don't want my entire life judged by the worst thing I ever did. And yet, if a sentencing defense attorney is not doing their job well, they're enabling, and in some sense, almost requiring a judge to do exactly that, to judge their client based on the worst thing they ever did without providing any context, without providing any other vision of who this person is in all technicolor detail.
From the very moment a defendant is involved in this system, someone else has control over their story. They want to define that person solely by the crime they may have committed. You have a sentencing date set, and the stakes are high. Both lawyer and client need to do everything in their power to prepare. But the question is, are you ready? I'm Doug Passon. I'm a 25-year defense lawyer, a sentencing consultant, and an award-winning documentary filmmaker. In Set for Sentencing, I'm going across disciplines and outside the box to help both lawyer and client expand their perspective, build on their skills, and get real results in the form of significantly reduced sentences. All of this in service to one goal: to bring more fairness, more compassion, and more justice to the sentencing process. So, are you ready? Then let's get set for sentencing. Helping us get set for sentencing today, a very special guest, and I'm so glad he's here, Professor Doug Berman. Doug Berman is a Newton D. Baker and Hostetler Chair in Law and Executive Director of the Drug Enforcement and Policy Center, which is housed in the Moritz College of Law at The Ohio State University. And one of the reasons I love Professor Berman is he has this incredible blog, Berman's blog, all about sentencing. And it is really required. I don't know a lawyer, especially in the federal system, who doesn't subscribe to the blog and read it religiously. And I am one of them, and I've used Professor Berman as an expert in cases, and I'm so glad you're here today. Welcome, Professor Berman, to Set for Sentencing.
Thank you so much for that lovely introduction. And I'm extraordinarily excited to have a chance to talk with you. And these are topics that have kept me excited and engaged for more than a quarter century now. And that's why I have that blog is not everybody wants to listen to me all the time, but the computer doesn't reject me when I get up in the middle of the night and scroll my latest thoughts down. And so thank you. And thanks to everybody listening and who go to the blog, because that's really why I enjoy doing it so much, is the engagement with the issues and the engagement with the people who care about the issues.
Well, the blog's an awesome resource, so thank you. And truthfully, I could have gone a lot longer, probably 10 minutes with your bio, but I found that, the folks that I have on the show, like you, have such impressive bios that if I spend the whole time reading it, we don't get to talk. So I'm putting it in the links, so anybody who's interested in getting all the articles and all the great stuff Professor Berman is into, go there. But let's dig in. And here's the thing. My thing is story, and you're a law professor. Now, I loved law school. I loved my professors. And I learned a lot, and I got a great education. I made some great friends. That said, once I got out into the practice of law, because I was already a guy who loved story and was steeped in story, that's how I viewed the world. And I said, that's all that we're doing here is telling stories. And I look back on my time at law school, and aside from maybe like a trial advocacy class or something like that, nobody talks that much about story and the importance of story in legal advocacy. And so I was just kind of wanted to get your take on it. I went to law school 30, I graduated not a long time ago. So maybe things have changed, but what can you speak generally this process that the law schools were training people to think and talk like lawyers, but that there's a potential sometimes to maybe disconnect from the human element of representation. What do you think about that? This is just me coming right out of the gate attacking the law school. No, but just what's your take, and has it changed? Maybe it's different now.
I love the question, and it has changed a little bit. I think every law school in the country, certainly mine, the Ohio State University Moritz College of Law, has a very robust clinical program that gives students the chance to work on, sometimes real cases, sometimes simulations that have them, going case by case, doing real lawyering work, and hopefully learning through that process about, storytelling and what effective advocacy looks like in real terms. I will say, and it's a wonderful first question to just sort of think about whether and how the entire structure of law school, I don't think by design, but I think to some degree, maybe by necessity, gets us away from the human stories, the individual realities of what the law impacts. So I would say, kind of ironically, against the backdrop of the case law method, in which discussions often start with an individual story, right? Whether it's, the Miranda case, and we'll focus on criminal justice stuff, or, Booker is another example if we're going to get into the particulars of federal sentencing in modern times. Those cases are so important as principles of law when they get all the way up to the Supreme Court or other appellate courts, whatever the jurisdiction that provides the cases in the case books, but they started as individual stories. And I think that one aspect of what law school is there doing, and sort of sees as this kind of thinking like a lawyer mantra, is don't get bogged down in that story, right? That one story is representative of some broader concerns, whether it's an abstract principle of law, whether it's, just a broader set of policies or principles that we're here to help you try to connect all these dots. And I do think, and it's certainly my experience teaching, especially first-year law students, criminal law, there is a risk that you get so focused on the story, you don't see the right. And so I think we might try to kind of beat the storytelling out of people on the front end harmfully, because I do think those stories are important. And I will say, and this is another element, and, at the risk of first question out of the box, stirring up critical race theory or other controversial topics, I do think one of the righteous modern criticisms of kind of the law as these abstract principles that we can sort of deduce, is a statement, and this goes back to the legal realists, 100 years ago, but I think is part of critical analysis today. You're leaving out the real people who are impacted by these abstract principles. Oh, and by the way, this is the more cynical version of it. Those abstract principles always get leveraged and operationalized to hurt certain individuals and to favor certain other individuals. And, that's where, again, I think the storytelling can help bring richness to all those dimensions to how the law functions. And I think it's a very valuable criticism, and one that I know the Legal Academy is always thinking and talking about when it comes to improving teaching and improving law school instruction. But at the end of the day, and this is the last piece of it, is the marketplace is going to shape how we do things. And if there are a lot of law firms and others who say, we're not going to hire kids unless they have a lot of storytelling experience, we'll tell more stories. But to date, sort of the same old, the case method, the traditional approach to a kind of a podium level legal education has generally been deemed by the marketplace good enough, even though there's been, generations of criticisms about teaching skills and values more. I think skills and values can be taught much more richly in that kind of storytelling component that you're talking about. So I think it's a great insight. I'd like to think we're doing better than your day, but I certainly would never say we're doing everything.
There's so much to unpack there, and the idea of, the human story, that we get bogged down. We start off, yes, case law starts, when we review these cases, it starts out with a story, but it's the story of the case. It's not the story of the person. And that's the interesting part of it. We never, I look back on some of these things, okay, a steel girder dropped on someone's head, and what's the issue, and what's the rule? And you sort of gloss over the fact that, oh, a steel beam dropped on someone's head. This was someone with a family and someone who has had a career. And it's so interesting because, we lawyers are this crazy breed. We're taught to dress a certain way. We're taught to talk a certain way. We're taught to write a certain way. But all of those things, for me, now a lot of people don't represent people like, they might represent a corporation or something like that. But for me, I found all those things when I'm trying to connect with another person and draw that story out of them, they're always barriers. There's so much otherization that goes on just in the very process of it. And I don't know what the solution is. I get what you're saying. We got to be trained to go out in the real world. But tell me what you mean. You said the abstract principles are leveraged and operationalized, and which basically affect different people differently. And I think I know what you mean by that. But give me an example. Let's put some meat on the bones there.
We're talking in the midst of, what I'm going to call the Roe's about to be overturned era, right? Where we've had this leaked opinion suggesting the Supreme Court's ready to really lean into originalism and textualism to, overturn Roe and say that there's no, constitutional right protecting abortion. And lots of people rightly are saying in response to that approach to overturning Roe, hey, women weren't even allowed to vote. Women weren't part of the conversation when the Constitution was put together. So, that abstract principle that we should really look to what the framers had in mind to define how this document should control modern day America, well, that necessarily cuts out certain folks. And it seems like, and lots of people rightly believe, it's a principle that helps guide them and is a better principle than some competing ones. But if you don't observe and are inattentive to how those principles will necessarily advantage certain arguments and certain populations over others, you're missing the full story of what's going on. And sometimes some people don't want to pay attention to that story. Some people are unaware of that story, but to be blind to it entirely and not at least be open to, we need to think about where that fits into our jurisprudence is again, where, storytelling is so important. And I'll add one more point. And again, it's interesting to think about, the context of how lawyers function, not just in law school, but in regular practice, right? Especially in our digital world. But even before we were in a digital world, we have access to pictures, right? And, a picture tells 1,000, words of a story, right? We have images all over. And yet, case books, the real standard fodder for law school instruction, still, look like they were printed in, on the Gutenberg press, 500 years ago. It's all text, all dense text, no pictures, certainly very little interest even in online textbooks where you could then link to go click to something that's a report or, we're still doing that old, analog approach. And the same goes for brief writing, right? I mean, it's one thing I know we've talked about this before, and I know you do work in this space, but, just being able to submit a video to a court, sometimes I think it's like you're asking to, fly a rocket ship to Mars. It's like, no, all of our kids are only looking at videos and little icons. And if we were to suggest, well, I'd kind of like to embed a couple TikToks in my latest brief, people would look at you like you were some kind of, crazy, modernist that just didn't understand. No. Law doesn't get done that way. That's not how law is done. And again, I never want to assert, because I don't think it's accurate to assert that there's some sort of grand conspiracy behind these norms. But I do think not just that they exist and that we don't question them very much itself is kind of a telling indication of different commitments we make as lawyers, as decision makers in legal institutions.
Yes, I love that you brought that up. And this came up in another podcast I was recording, but the theme was question everything. It was in the context of forensics, but that's really my MO for this whole thing and this whole legal endeavor. Just because it's been done that way for hundreds of years doesn't mean that it shouldn't change. It has to change. Everything changes in this society, and it's changing really, really fast. So even if you're not doing a video, I say put those pictures in a pleading. Why not? And the other thing, I'd be interested to hear your take on this too, because you mentioned the generations that are coming up. They are so visual, and it's all YouTube and TikTok and these types of things. But it's also small bites. And we're AD, like we have very short attention spans, and our content, people, even I don't see movies anymore. I watch shows because they're a half hour, an hour. It's my That's as much focus as I can have, but yet we're still doing these briefs that are like 100 pages long, full of boilerplate case law and all this stuff. And it's like, how? At what point are we gonna shorten everything up to adjust to the way our brains are developing in this culture where we're just inundated with like bombarded with avalanches of information all day, every day? Is that changing at all in the way we're approaching that with students?
I think it's changing in practice, but not in many formalities to date, right? And I think you put your finger on one issue that's worth watching closely, and I can link it back to my blog where this is 2004. It was fairly controversial, and there was much sort of churn among law professors in 2004. Should we be blogging? Is that an appropriate thing for us to do instead of writing these long form articles? And can we influence courts? And and I just love it, in part because I guess I have that short attention span problem as well. And yet, ironically, especially with Twitter, now blogs are like, oh, that's grandpa's technology, where it's so long and you read all this stuff and I need to see something that's 140 characters and I can scroll through 17 posts in 8 seconds, and that's how I'm going to sort of consume in these bite-sized pieces. And you're absolutely right that my children, it's TikTok, it's other novel new media that are my sense, my understanding is it rewires all of our brains, and then and maybe this is itself another layer of why law school has been, kind of resistant to this kind of evolution is no, that's not a great transition, especially for a topic, which I would be quick to say law is, that needs careful, deliberative, sustained thought. And that you've got an idea, it's not enough to have a catchphrase, dare I say, defund the police or something along those lines, without all the explanation. And politics and rhetoric aside, I think that's where we're going to keep both in practice. And then I think at some point in policy, sort of struggling through, because I do think a next generation of lawyers, a next generation of judges, next generation of law professors are going to be inclined to use these tools more. And just as I was with the blog, see these tools as having some benefits over some of the more traditional means of communication. Again, whether that carries over to kind of actual decision making is interesting to debate. But just as one, for example, in the legal classroom, when I started teaching 25 years ago, PowerPoint barely existed and nobody used it in the classroom. Now everybody uses it in the classroom, right? And it's a little bit because it's a better communication technology. That's now the norm. And it's interesting to imagine a set of courts or just a set of decision makers in law becoming really proactive and saying, what, we are going to accept video submissions or something else. And if they did that and did it to good effect, would that end up, moving the needle a lot more quickly? Again, one of the reasons lots of people like law is because it moves slowly and reactionary and has precedent and doesn't get caught up in the latest wave. And so, again, I think it's all in development, but especially if we shift to sentencing, I think that's an arena where we can see even more innovation. But of course, it's got to be tailored to the needs of a client, the needs of a lawyer, the needs of the system effectively for that innovation to be accepted.
Yep. And I've found in the beauty of sentencing is usually the rules of evidence don't exist. So in terms of being able to present anything effectively to a judge, it's wide open. The real question is, will the judges be receptive to these new means and modes of advocacy? And by and large, the answer is resoundingly yes, that I've found, especially in federal court. I mean, the sentencing videos are becoming way more prolific. They even just did a Simpsons episode about sentencing mitigation videos. True story. But so it's a thing. It's happening slowly, but the shift is there. I had a lawyer I had lunch with the other day who said he submitted a video, and the judge asked him, "Why aren't more lawyers doing this?" And it was so encouraging to hear that the judge actually, wanted more wanted more of it. And I actually think from a judge's perspective, if you went into their chambers, you'd see a stack of paper like 6 miles high. That wouldn't they rather see a 10-minute video than have to plod through some boring brief? But you must feel very smugly satisfied when you started the blog and everyone said, should we be doing this? Because I'm reading your bio, that blog's getting like 100,000 page views every month or something like that, right? So I feel like maybe,
I get a good bit of traffic, and I think sort of the right place at the right time. I literally started my blog a month before the Supreme Court decided the Blakely versus Washington case, which not only disrupted Washington state sentencing guidelines, but then laid the foundation for the Booker ruling. And so I was kind of again kind of right at the moment when everybody wanted and needed information in real time.
Yeah.
Now we get a lot of information in real time about everything, but less true back in 2004. And then the other thing that I really was eye-opening as an academic, was so valuable and meaningful to me working on the blog at the outset, and has sustained me for almost 20 years now, is there's such an incredibly robust and diverse community of interested and impacted individuals, right? So you obviously have the judges who have to sentence, you have the defense attorney and the prosecutor who have to make recommendations about sentencing, and you have the defendant and the defendant's family. Those are just a significant set of people involved in that one case. And then, of course, this is the part that still makes my head hurt every so often when I really think about it, just how massive our systems are, right? We have, roughly speaking, now 60,000 federal sentences in each year. That sounds like a lot. It is, because it means literally a couple hundred a day, right? So all those people I just described every single day times 200 trying to kind of work through these issues. Yeah. Then you have, roughly speaking, about 1 million felony convictions being sentenced in the state courts every year. So that's, times that by 10 and plus, thousands of people every single day being subject to our sentencing system. And of course, as you know well, as everybody listening to this probably knows well too, it's not just at the time of sentencing that sentencing matters, right? It's when you're getting charged and the prosecutor is thinking about what charges to bring. They have a mind's eye at sentencing. Certainly, once the defense attorney counseling about plea arrangements and terms of that, that's a sentencing conversation. Now, everybody in prison, whether we talk about compassionate release in the federal system or a variety of other tools in state systems, how can I get resentenced as the law is changing in all of these ways? And so, one of my parlor tricks has always been, tell me an issue about not just the criminal justice system, but anything going on in our society, and I'll tell you how it has a sentencing spin, right? And that's where I think I feel the most smugly satisfied. It's not even so much, a lot of people wanted to go to the blog, and I felt it was a good investment of my time and served me professionally, and hopefully others well too. It was, I'm right that sentencing is this consequential and this challenging for so many people every single day. And so that's really where the satisfaction comes. And then I hear from, whether it's folks like you, whether it's, people directly impacted by the system, people, working as lawyers, that, they benefit from not just the information I try to share, but from, kind of a resource that isn't a treatise or isn't, something that you go to and all you're going to do is sort of be depressed by what's going on in the world, or trying to figure out what you need to know. It can just be, almost a bit like, an online magazine that is worth checking out, and yet you'll know it'll be done. I really work hard, not only to make the discourse sophisticated, but to be really accurate, right? So that I hope I have a reputation. You can trust what I'm doing, and I try to link, of course, to all the resources that I use. And that's itself another thing that over time has become even more important to me as a part of doing the work, because as we know, there are so many sources out there now that are so partisan, or that are, whether by design or by just inclination, pushing a message rather than pushing information.
Right. I love your parlor trick, and I'm gonna have to use you as a resource, because, well, first of all, what you said about over 1 million people a year getting sentences was completely my inspiration for starting this podcast, because it is so consequential. And we lawyers sometimes tend to look at sentencing as an afterthought, especially if we've gone through trial and we're exhausted and we lose sight of the real, given that 95+% of people who are charged end up at sentencing, that's where the real work comes in, right? And I love that you said that, and I love your parlor trick, because as I'm doing this podcast, there are definitely topics that I'm so interested in, and I go, well, I'm not sure, how do I relate that back to sentencing? But I'm just going to send you an email going, I'm going to have somebody on. You tell me, how do I? But everything is related to sentencing, of course. Your blog is, there's two parts. I was just reading every day as I do when it comes, and the two things hit me over the head like a ton of bricks today. One was just it was about Arizona, it was about my state, because we revved up the death penalty machinery again and started our executions back up, and the first execution happened yesterday. I don't want to talk about that. It's a whole other podcast topic. It just bums me out. Obviously, in terms of sentencing, that's the ultimate sentence, the ultimate penalty. But the other thing in there was that President Biden has gotten motivated to get the United States Sentencing Commission back in action, that they've been basically dormant for a ridiculously long period of time. There's a new slate of proposed commissioners that's listed in your blog. And I just want to get your take on, what do you think what can we expect? Well, first of all, what do you think of the proposed folks? And then what can we expect is coming down the pike if they get revved up again?
Thanks for those questions. I'm actually going to use my prerogative to let's talk about the death penalty a little bit, even
Okay,
though you're absolutely right. It's another blog, but here's why I'm going to bring it up. Not only because you mentioned it, that I covered the execution in Arizona yesterday, but I really work hard to cover both capital and non-capital sentencing stories, because I think they have so much to learn from each other. And one of the things that has been a kind of, I don't want to say a surprise, but notable for me, both among academics, but also among obviously practicing lawyers and policymakers as well, is a kind of tendency to have a very sharp divide between, here's the capital sentencing people, and they write articles about capital sentencing, they litigate capital sentencing cases, they know, and of course there's so much jurisprudence, the capital sentencing case law, and yet that's all they do. And of course that's not true for lawyers practicing in the system, but it is very much true for a lot of the writings in the academy and in a lot of advocacy groups. It's an anti-death penalty group or it's a pro-death penalty group, and we're going to just drill into that story, and there's plenty to drill into. But then there's the non-capital folks, and those even often get divided by jurisdiction, federal versus state, individual states, and all of that. And yet, and this is again part of the joy of being in an ivory tower, 10,000 feet above it all, I can see all these systems, and I think it's actually quite important for people to see. Sometimes they're parallels, sometimes they're contrasts, right? One thing, just to use the death penalty as a good, interesting, for example, right now, I sense on the GOP side, especially, we saw this a little bit through the confirmation hearings for Justice Jackson Brown. We're certainly seeing it in a lot of rhetoric against progressive prosecutors and the like, back to a tough on crime era, right? Or at least back to tough on crime rhetoric. We have homicide that is increased quite dramatically, in the last couple of years. I think that's a pandemic phenomenon, but whatever else you want to say, that's been part of the driver. Concern about property crime, concern about shootings, you name it. There's certainly the foundation in fear of crime to drive tough on crime rhetoric, and we're seeing it across a number of quarters, except, he says, pausing dramatically, in the death penalty arena. We're seeing a few more executions, but we're not seeing what we saw in the 90s, where we saw dramatic support on both sides of the aisle for, we got to ramp up the number of executions. We got to increase the number of offenses that are death penalty eligible. We've got to make sure there aren't so many appeals. I think there may be a little of that brewing somewhere, right? I definitely think there's we saw it especially in the tail end of the Trump administration when Attorney General Barr pushed very hard to get some federal executions through, but that's still really the outlier right now, right? And we're seeing, notwithstanding a tough on crime pushback on a variety of other fronts, it's not yet finding any real expression when it comes to capital punishment. And I think for those who are concerned about how capital punishment operates, something to celebrate, or maybe reason to be fearful, oh, that's the next frontier at which, the tough on crime crowd is going to go try to make hay. But given particularly how much in the 80s and 90s advocacy for capital punishment was driven by, I think it deters murder. I think it's the way we should respond to homicide increases, that we've not had that kind of response again 2 decades later is worth noticing. And that's what I do, right? I do for a living is I notice things and I talk about what I notice without necessary solutions. And so, reflecting on that is only really possible if you see what's going on in the non-capital discourse and then say, interesting, it's not showing up yet in the capital side, and vice versa sometimes, right? That there can be, my sense is there's a persistent conservatives against the death penalty conversation that sometimes crosses over to other punishments and sometimes doesn't, right? And all of this is moving, in a lot of sort of politically shrewd ways. I give you a huge backstory because I think that's for me the biggest question with these new commission nominees. As the Sentencing Commission has to by statute, it's got 4 Democrats.
Well, wait,
people in 3.
I don't want to interrupt. I mean, I do want to interrupt because before we move on to the commission, you've given us hope. Like, I love, this can be doom and gloom a lot of times. We're talking about sentencing, but you're talking about the death penalty and the machinery is slowing down. That to me is a hopeful thing. But my question is, what do you think is behind that before we get to the commission? Like, why is that happening?
I love that you asked that question because I think this is the moment at which I think rightly praise defense lawyers and showcase what I believe is the greatest example of a committed defense bar prepared to do everything possible to raise every possible argument against state killing. By definition, on behalf of the most reviled clients. I think the defense bar deserves credit for slowing the machinery of death, gumming up the works in part because they keep trying, right? I lose this lethal injection case in the Supreme Court. I got a new argument. I lose that one. I got a new argument, highlighting innocence issues, obviously, right? And so we, out of Texas, I was still stunned that there is such a compelling innocence case that got so close to execution, but it's a combination of the defense bar doing the storytelling in individual cases that has moved courts. And I think a public that has been educated about how problematic this system can be and how little they care if there's 5 executions a year or 8 executions a year or 12 executions a year, right? And I think that's part of it. My favorite variation of this theme when I teach about the death penalty is what was known or what got called the Marshall hypothesis. Justice Marshall famously said, the more people know about the death penalty, the less likely they are to support it. It's only that the citizens don't really know the details that they vote at the ballot box for an advocate for the death penalty or that they're supportive of it. In theory, once you know the details of how problematic it is in operation, people turn against it. And though, again, this is itself part of where the defense bar deserves credit, the public, that's actually not been true, at least as a matter of public general polling, right? We've seen ups and downs, but support for the death penalty still tends to trend 60%, roughly speaking, depending on how you ask the question. But what defense attorneys are doing and finding success is they're educating judges about how this system works and consistently making judges uncomfortable with how that functions. I've especially seen that here in Ohio, where I'm fortunate to have actually a fantastic former student of mine who's been incredibly effective in highlighting all the challenges of lethal injection in the state. And it really has been just the strength of his litigation skills in highlighting and presenting evidence of just how problematic this process is. And judge after judge, a lot who, based on who appointed them and their history, you would think would come to the question kind of skeptical, look at this stuff and just say, yeah, this is a problem. Or, interesting, occasionally they'll say, you know what, I'd vote against the death penalty. I'm not sure it's my role as a judge to say it's unconstitutional, but, the more they see how ugly the system is, how hard it is to kill people efficiently and effectively, that's a success story for the defense bar, though against the backdrop of what I think is this accurate hypothesis that the more people see and think about the system, the more distasteful they find it, the less comfortable they are with how it functions. And so, again, I say that because one of the things I've emphasized in other settings is, boy, if we bring this energy to other parts of the system, and by we, I do at times think of myself as a defense attorney, since I do some of that work on occasion, anything's possible. And we've seen this, sometimes with sex offender registry, sometimes with juvenile sentencing. There are other pockets where we see really effective, really sustained, really aggressive defense advocacy starts moving the needle for courts, and then it ends up moving the needle for prosecutors and for elected officials. But it's hard. It's a lot of work. And again, this gets back to the system is so huge, you can't fight every front at every moment.
Right. Yeah. I'd like to think, I love that you say that the narrative aspect of the lawyer's work is moving the needle in death penalty. I'd like to think that also, just in terms of, you speak about the narrative aspect in the systemic dysfunction of the punishment. But I'd like to think that lawyers have really gotten so much better at telling the story of mitigation, like deep dive into the human story of the individual offender, to the point where, I don't know if it works this way in every jurisdiction, but the lawyers in Arizona are doing, putting together a massive story of mitigation to the prosecutors before they even decide to put death on the table. So, I wish we had I'm sure somebody's done the research of how many times good defense lawyers with great mitigation have headed up that whole thing off at the pass. And then getting to trial, how many jurors are just hearing the real story, the full context of a person's life, and going, I'm not going to kill this person. I'm not going to do it.
Well, and there I'll emphasize, and you put your finger exactly on it. I think the fact that we have jury sentencing in capital cases, and that the jury decision making is fundamentally a mitigating decision making, right? So every capital case, sadly, is such a serious offense that most states have already provided for, at least 20 years, maybe at least life, and then death is that kind of that next stage. And the jurors know, all right, at this sentencing stage, I'm not being asked, where 0 to 100 to weigh in. I'm being asked, is this the worst of the worst? And in that context, particularly, I agree with you so much. Defense lawyers have gotten particularly effective over time at convincing jurors, no, not the worst of the worst. And of course, that influences the prosecutors, because the prosecutors don't want to bring a case that they think they're going to lose at the jury stage. And so absolutely, and it's actually one of the many reasons I've long been an advocate for jury sentencing more broadly, but wanting that jury sentencing to be structured around, does the jury think this person deserves a break, rather than how harsh or soft should we be on this person, right? So, imagining a world, and again, it's one that is easy for a ivory tower academic to imagine, harder to imagine putting it all together and getting it done. But imagining a world in which whenever a defendant is subject to a mandatory minimum, they get a right to argue to a jury, to have the jury say, no, this doesn't seem like a mandatory minimum case, right? And if, again, that were the world we were in, prosecutors would have to think before they charged a mandatory minimum, am I going to lose before a jury when this defense attorney has already shown me this terrible childhood, or, a variety of other mitigating contextualizers that probably really isn't the worst of the worst. But of course, we've got the flip of that now in most non-capital cases, where what the prosecutor's thinking is not, will a jury agree that this is a person who deserves this? It's actually, will this allow me to then say to the defendant and the defense attorney, unless you cooperate or unless you plead guilty, you're facing this. And so now we have this incredible incentive, mostly thinking of the federal system, but this works in the state system as well, not let me worry about charging that the jury might reject. It's instead, let me enhance the charges that give me more leveraging and plea bargaining power because it's going to be just the defendant and the defense attorney who thinks about this. And of course, this is what always bothers me most is the ethical, competent defense attorney has to say honestly to every defendant, yeah, the reality is if you go to trial and lose, you're getting a worse sentence, probably a much worse sentence. You can't hide that fact from your client, even if you don't think your client should plead guilty, even if you think your client is innocent. You're duty bound to help them understand the lay of the land. And that, again, so differentiates the world relative to the capital punishment system, where a defense attorney can and will tell his or her client, mostly it's his client, we're going to get a chance to talk to a jury about why you shouldn't be executed, even if you did this horrible crime. Hey, on day one, start telling me the things that are important for me to build a mitigation file, right? That's not just, it shapes the prosecutor. Defense attorneys knowing when and how and kind of where to direct their resources necessarily shape their relationship to their clients differently in these different systems. And so, that's and again, that's back to my theme of there's a lot for non-capital defendants and defense attorneys to learn from capital ones and vice versa, but it's where an academic can say, look at how these different incentives and different decision makers end up structuring, kind of how the system functions and the work of the players of the system in a different way.
Absolutely. And the idea of jury sentencing in non-capital cases is mind-blowing, and I love it. I haven't thought about it, but from a defense perspective, it's not even that the jury has no say in the sentencing. They have no understanding of the implications of their verdict. We are specifically precluded from talking about sentencing in any way, shape, or form during the trial. And in Arizona, in the state case, and federal too, we have these, enhancers that make a mandatory minimum. Well, in the state case, they check a box. And for example, one of the first trials I ever did, it was an aggravated assault where a guy pointed a gun at somebody. He didn't shoot him. He just pointed a weapon, but that's assault, aggravated assault. But because it involved a firearm, there's a box you check. Did it involve a firearm? Duh. And if you check that box, it's a 5-year mandatory minimum. So the jury doesn't understand when they check that box that they have just predetermined the sentence. And if they did know that, forget deciding what the sentence should be. If they knew that simple fact, they would be able to exercise their right of jury nullification, which we like to pretend doesn't exist either. But they would say, wait a minute, if I check that box, I'm sending this poor little kid to prison for 5 years. I'm not doing that. And that seems to me like justice, but that's not how our system works. It's fundamentally broken. But I cut you off. I'm going to get us back. I'm going to actually have to have you back like 10 more times on this podcast. But let's get back to the commission. Tell me about what your thoughts are there and whether there's going to be some. My theory on the sentencing guidelines, just so you know, real nice experiment. It didn't work. Scrap the whole thing. These guidelines are garbage. We know that, and the judges understand it because they're deviating downward variances in, the majority of cases. These things they suck. They don't work. They're dehumanizing. They reduce a person's whole life story to numbers on a chart, and I despise them with the fires of 1,000 suns. Now, are the guidelines going to go away anytime soon? No. So what's going to happen?
It's a great question and a great setup to what I think there's more than a few of us eager to imagine a new commission could take a full, fresh look at the entire system, right? One thing, so we've gone a full 3 years without having we had one commissioner, but any functioning quorum. We've really gone a decade without having a fully staffed commission that was sort of well positioned to ask some deep, hard questions about the system as a whole. And so one of the things I think is a big uncertainty and possibility would be, lots of advocates. And again, it would really probably require some members of Congress, certainly members of the Department of Justice, certainly the federal public defense bar in a variety of forms. I think a lot of academics as well advocating to this new commission. They still have to get confirmed, so I'm not even going to take them for granted yet, but imagining they do get confirmed, advocating for this new commission to take a deep, hard look at the system as a whole as it's functioning. And there's a bunch of, I think, really strong arguments for why that ought to obviously be what their vision of their task is. First and foremost, 2 of the last 3 chairs of the commission finished up their tenure, really part of their tenure, and said, this system's badly broken. We got to do a lot better. And both of them said we need a simpler system where there actually are more jury trial rights, or at least, it's a mandatory system, but one where you have to prove up all the aggravating factors beyond a reasonable doubt to a jury in order to be valid. And so, the last sets of people who have been here have looked at this system and said, this isn't working, and we need to take a new, bold, fresh look. In addition, the American Law Institute recently ratified its revision of the Model Penal Code sentencing provisions. And among the things they said quite wisely is that every sentencing system, I think they say at least once a decade, but certainly we're going now on 40 years, needs to do a wholesale review to see if this is working, right? And so here you have the expert academics, you have the people who function in the system. You articulated it beautifully, and I think there'd be many more like you, myself included, who would say, look, this system just is not working. Let's do a reboot, or at least let's take a serious look at a reboot rather than keep tinkering with a broken system. The concern, though, and I think this is more likely to happen, is there's so many pieces of the system that can and need to be kind of cleaned up just because there's been 5 years of inattention to the commission. There's the compassionate release guideline, which courts are split over because it's badly out of date after the First Step Act. There are other provisions of the First Step Act that need to get implemented. There's ongoing debate over the crack equalization statute that may or may not get passed, that if it gets passed, you got to revise the guidelines around that. There's other data points that have been brought up by the staff of the commission that's still been working all this time about little problems that need to be addressed. And I'm quite concerned that what's likely to happen is they'll get there, and rather than say, let's step back and spend time looking at the whole system, they're going to start, sort of drinking from the fire hose. And the fire hose is just going to be all these little issues that seem like they're doing a lot, feels like they're doing what they're there to do, and yet it kind of lives up to your prediction, which is we're not getting rid of the guidelines anytime soon, and we're just trying to tweak the system to make it a little bit better. Now, is that a certainty? Absolutely not. Is it likely, even if they did take a step back and they studied the whole system, that they'd come back with something bold that could actually get through Congress and become law? No. And I think this is one of my sort of strange little insights after Booker. Folks may remember, and I always like to remind people that Justice Breyer, when he wrote the remedy to Booker, kind of wrote expressly, okay, this is the best we can do right now. It's up to Congress to make this better. Well, interestingly, I think as of this year, I keep meaning to blog about this, we've now had an advisory guideline system longer than we had the mandatory guideline system. And so, that is now the norm, and certainly the norm going forward, this advisory guideline system. And what's so interesting about it is it ends up, for at least the players on the ground, working well enough, and certainly working better than their fear of the alternative, right? So when then Judge Pryor, then Judge Sessions said, we ought to have a mandatory system that's a lot simpler and requires all these things to be proven beyond a reasonable doubt, but with broader ranges, I think the average defense attorney, especially in New York or California, LA, they've got judges they know who will go way below the guidelines, are like, I kind of like the advisory system for my clients because I know how to talk to my judges the right way to get them to go below these crazy guidelines. And they've said on the record over and over again, the economic fraud guidelines are crazy, or the child porn guidelines are crazy, or the drug guidelines are crazy. And gosh, if there's a whole new system that doesn't look quite so crazy, maybe that'll be better for my clients, but I'm not so sure. And I'm nervous of the unknown. I think the same goes for the prosecutors. I think the prosecutors would like a more mandatory system, but they're a little scared of, really, we have to prove the amount of loss in the fraud cases. Really, we have to prove beyond a reasonable doubt the amount of drugs in the drug cases. I think I could do that in most cases, but I'm not so sure, and that worries me. And you know what? This is close enough, and yes, I got to cut better deals or all that, but At least I don't have to spend all my time, litigating before a jury whether it was 1.5 kilos or 3 kilos, and that's not fun anyway. And so I think there's ended up being built into the advisory system as it currently is constructed. All the flaws that are easy to identify, particularly in an individual case, particularly for those commissioners looking at the system as a whole. Yeah, but am I sure I'm not going to be able to use those flaws to my advantage more often than if we create a better new system, right? And that's especially where us academics are keen to say, yeah, but the whole point is a better new system. Come on, let's do better. We can do better. I know we can do better. The states do better. It's very possible. But for the actors in the system who are risk averse for all sorts of sensible reasons, the devil they know is at least more dependable than the devil they don't. And then last point about this, and this is the last point that I think is makes my head hurt. Given that we had these extraordinary transition costs getting the guideline system in place to begin with, and then of course 15 years into it, it got blown up as unconstitutional, and on and on and on. There's also, I think, at least a smidge of a philosophy, not just the devil we know is better than the devil we don't know, but there's a lot of devil in transitioning to something. And so, hey, if we can just keep tweaking and keep making it a little better and a little better and a little better and a little better, maybe that's the better path to some kind of justice than a big rip the Band-Aid off and try something completely new, because who knows where that'll take us.
That is a lot of food for thought. I feel like you just convinced me that we shouldn't scrap the guidelines, because it is the devil I know, and I know how to navigate those now after 20 some years. And, I guess maybe the solution is to sort of identify the most egregious components of those guidelines and scrap those. And I'm thinking about relevant conduct. And I'm thinking about the burden of proof being so low to prove enhancements that completely upend the guidelines, and tails that wag the dogs are everywhere. I'm thinking about some sort of rational relation to reality when it comes to drug quantities or fraud guidelines and things like that. So maybe that's the deal. We've got to hammer away at these. But if you could make one change tomorrow, if you were king of the commission and you could make one change to the guidelines tomorrow and you only got to do one, what would it be?
All right, so this is a unfair but perfect answer, and maybe conclusion to our conversation even, which is I would decree, maybe this would be by statute, I'm not sure it would be commissioners could do, but if I was chair of the commission, I'd say something along these lines. We ought to have as much parity as possible in the guidelines when it comes to aggravators and mitigators. So I think one of the many reasons the system is so tilted against defendants and so problematic, and again, this is back to that capital story about how things function. Every one, save maybe 2 or 3 factors in the guidelines, are aggravator. And so that's not only something the prosecutors attend to, but there's very little the defense attorney can sort of do about it except complain. Really? You proved that aggravator by preponderance, or you said 8 different guys were on 8 different corners selling 8 different drugs, and somehow my guy now is responsible for all of that. It's like, it's both the factors that we're focused on and the way aggravators function so easily to be piled up. And yet there's no corresponding mitigators other than rolling the offense as a mitigator, safety valve as a minor mitigator in drug cases, and then ultimately acceptance of responsibility. That's all your mitigators. Now, some of them are departures, right? This comes into variances. Why has Booker been so valuable for defense attorneys and something they can leverage into below guideline sentences? It's because all the mitigators now are getting action through the 3553A factors. And that's all fine in a sense of like, yes, actually, we do have more balance now because there's something the defense attorneys can talk about and that can be given effect by the judges. But I think we ought to. I think it would be healthy to. I think it would be hard to, but important to codify a lot of mitigators so that there's as many factors there, and it can be, and again, it seems off-putting because it makes us uncomfortable. So -2 because the person had a history of substance use disorder, why are you giving that -2? Well, my flip of that is, why are you giving aggravating role +2? You know, like, it's all funny math, and yet the funny math all seems to be about driving the sentence up and not all about identifying and then channeling judicial discretion around mitigators, right? And so if I had one thing I could do, it would be to try to build mitigators more systematically into the guideline structure. And if we couldn't figure them out, that's why I'm talking about, hey, you can't figure out a good way to make all these mitigating factors into actual guidelines, then you got to get rid of some of those aggravators, because those should just become variance considerations or departure considerations. It needs to be a book that's balanced and that calls the judge's attention in a balanced way to both classic aggravating factors and classic mitigating factors. And, as you know, and those who have done this long enough to remember the old departure days, right? So many of those mitigators were just deemed not ordinarily relevant, right? And put, off limits as departure. Beyond the fact that they shouldn't be off limits as departure, they should be guidelines. That's the idea of guidelines, is to create a rational, consistent method for judges to think through issues. Why can't we consistently think through which mitigating factors? And of course, as is always the case, I'd still probably make this system advisory. Oh, this person had a substance abuse disorder, they get a -2, but then they went and did all sorts of other terrible things and actually addicted a whole bunch of other people to drugs, intentionally to steal their money or whatever. All right, I'm going to vary and not give you that -2 credit anymore, because you're not the type of classic person who ought to get that. Dare I use Justice Breyer's framing of heartland of who we're talking about here. But I think that's the kind of big structural problem with the guidelines beyond much else, is this incredible imbalance between aggravators and mitigators.
I love it. And it feels like if there's a theme to our discussion today, it's what can we learn from the world of capital litigation, because it feels like that's something that happens. There's statutorily in a lot of these cases, there is a long list of mitigating factors that you can allege, right? Here's a good mitigating factor on the guidelines. How about no criminal history? Our guidelines say, well, it's great if you have no criminal history. That means we're not going to ratchet up your sentence by increasing your guideline, your criminal history category, but we're just going to keep you at the first level. Well, how about if I've gotten through my whole freaking life without getting in trouble before? That seems like mitigation to me.
Absolutely. And of course, if you read the original Sentencing Reform Act, it expressly suggested a presumption of non-incarceration for essentially non-serious first offenders. Now, how you define serious becomes debated there, but it's not just that people with no criminal history ought to get a break. It's we really ought to have a presumption against incarceration for a much larger percentage of defendants.
Okay, so wait a minute. This is big, because I'm not aware of that, and so point us to where we lawyers can invoke that, because that is a virtually non-existent idea in the federal system. Everybody goes to prison.
It was a provision. I'd have to get the exact site. I think it's 994 in 28 USC. It's an instruction to the commission.
Okay.
It says
I'll put it in the link.
Commission. Oh. Yeah. Oh, and the commit, and here's how it's again, textured as always. Commission, when you're writing the guidelines, go to the max for the career offenders and have generally an alternative to incarceration for first offenders not involved in serious offenses, right? Which again makes sense as a concept, right? And yet, as it applies, it doesn't work that way, right? And so, there's ongoing efforts to encourage the commission to invest more in alternatives to incarceration, right? That's another piece that has kind of gotten left out of guideline discourse, although the commission, to its credit, held sessions and did research and tried to kind of support innovative programs in different districts that were trying to do diversion or things along those lines. There's a lot of good energy, both past and present, that again, I guess back to the fundamental question of what's this new commission going to do? If they came in and said, we're going to use our knowledge, the freshness here, and not only try to take everything a close look, but say something like living up to President Biden's pledge to cut prison population should be fundamental to our work, that will look a lot different than if they're just, well, crime's up and we got to do something about that, right? And so, again, this is where the fact that it's a bipartisan commission makes me hopeful that there'll be lots of perspectives brought to bear, but one's core philosophy / sort of presumptive commitments, right? And, there can be, in fact, again, this goes back to, kind of interesting signs of the times, right? The federal prison population got up to 220 during the kind of middle of the Obama years because there was nobody really aggressively saying we got to do something about mass incarceration. Then not quite a flip switch, but more attentiveness was given to this issue relative to other issues. Then there was also a pandemic. Then there was also the First Step Act and the Fair Sentencing Act and all that. And we're down to like 155,000 now. I give that history because it's possible. It might be probable that there are some voices in the tough on crime set that would say, we got to get back up. This is a problem. That's not the natural where we should be. We're too under incarcerated. I think Senator Cotton likes to use that idea that we have an under incarceration problem. But I came at this by wondering, why can't we get back to Reagan era levels, right? Where we were at 100,000, even less than that federal prison population. And that's just one of a number of, viable metrics to use as a way to judge what we're doing and how we're doing it. But again, that's where, one has to have a bold vision coming in, and it'll be interesting to see. This has been another aspect of where the commission as constructed, always having a bunch of judges, always being chaired by judges, has made them kind of by inclination slightly more, I would say, sort of little c conservative, right? That they don't see their role as swinging for the fences in this body. And it's easy for me as an academic with tenure to say, swing for the fences, who cares if you strike out, just take a shot. And so, I want to be realistic about what we could reasonably hope for. But I do think the environment is right for a bigger move by this commission philosophically. Whether these 7 folks who have been nominated will embrace that, it's. I'll be watching it closely. Read the blog. I'll read tea leaves along the way as well.
It feels like hope. There could be some hope there, which I love. Before we go, a couple things. One, I was going to have a whole other topic, which I think is going to take way too long, but I think it bears giving you a plug, which is to say our origin story together. The first time I actually personally interacted with Professor Berman was that I engaged his services as an expert on a case. It was a clemency pardon case where a client had gotten the highest sentence ever, literally, in the country for a biofuels fraud case because the fraud guidelines are ridiculous. And from our perspective, the representation he received at sentencing was deeply flawed on many levels. And so we engaged the services of Professor Berman to review the transcripts and the available materials and render an opinion about what is effective assistance of counsel at sentencing. And so, I would encourage anybody listening that, if that's an issue, this is a great resource. Even just having the blog is going to educate you in ways you cannot imagine. So the blog's going to be in my show notes. Hopefully I'll get a few new subscribers. But I want to give you the last word, and basically, I gave you this homework assignment very late in the game. It was an hour before we went to record this. But I have this template that I learned called the Dobzhansky template, and it really helps me zero in when I'm doing my work and focusing in on a case. What is the real driver here? What is the issue? And what is the one thing that defines the entire system? And so I put it to you to tell me what your Dobzhansky is when it comes to sentencing. So it goes like this: nothing in the American sentencing process makes sense except in the light of blank. Do you have that one thing?
I'm not sure I have that one thing, so I'll resist the question like a good law professor is inclined
It's
to do.
hard.
I will
It's hard to
say,
do. It's hard.
and this is where I do think it may come full circle to a lot of what we've talked about, which is a phrase that I often hear other people say, and I really actually like as a thought for not just sentencing, but sentencing representation and advocacy and beyond, which is, I know I would never want my entire life judged by the worst thing I ever did. Simple stop. Say it again. I don't want my entire life judged by the worst thing I ever did. And yet, if a sentencing defense attorney is not doing their job well, they're enabling, and in some sense, almost requiring a judge to do exactly that, to judge their client based on the worst thing they ever did without providing any context, without providing any other vision of who this person is in all technicolor detail. And that to me is where I've written some articles that talk about the offense versus offender distinction. And for me, the trial, the guilt determination can, and in some sense, sometimes, not always, but sometimes has to be only about the offense, that worst thing the person did. But when it comes to sentencing, that's exactly the time at which our system is eager to know the fuller story, know all the details. And that's what talk about what makes for ineffective assistance to counsel, when the counsel doesn't give those details and lets the story just be the worst thing the person ever did. More often than not, thank goodness, we don't have ineffective assistance of counsel. We just have less than fully effective counsel, because for a variety of reasons, prosecutors are very good at focusing the judge only on what the defendant did rather than these broader stories. And for me, maybe the right answer to the question is, what the sentencing system is about for a defense attorney is telling that full story. Because at the end of the day, our laws actually want the judges, demand that the judges pay attention to that full story. And yet, if that story is not told effectively, and of course, our clients, defendants, aren't always going to be good at doing that at any point, let alone, not long after they did the worst thing in their lives. That's what defense counsel can do, needs to do. And again, it's a challenging thing to do for all sorts of reasons and all sorts of settings, but that's what the system asks judges to care about, that stuff. It depends on defense attorneys to provide that material effectively to the judges so they can do the job the way our system wants them to.
So well said. So well said. I can't add another word to that, so I think that's a perfect place to wrap up. If you're interested in subscribing to the blog, it's just sentencing.typepad.com, I think, right? Or you can Google sentencing law and policy or
That's
Professor.
You got it.
Yeah, and you'll get right to it. It's amazing. It's an amazing resource. You are an amazing individual, so I really, really want to just say thank you for everything that you do, and thanks for coming on Set for Sentencing. It means a lot. We learned a lot.
I'm very grateful you invited me. I'd love to come back again and talk more about all these issues. Maybe once we see what the commission starts doing, we can talk more about some of those specifics. And I'm incredibly grateful you're taking the time to put all this together, and I hope there are a lot of folks out there who are taking advantage of this important resource as well.
I'm absolutely going to take you up on that offer, so we will be speaking again soon. Until then, be well, take care, and keep up the good work. That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you like the podcast, please do me a favor. Spread the word about Set for Sentencing and give us a rating and review on the iTunes podcast platform. It would really help. Last but not least, if you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.